Okay, evening. What day is it? It's Monday the 20th. I've been off today working on this letter, plus a few other things, and I'm off tomorrow, or pretty much off tomorrow, hand delivering this letter to my merchants that I buy my stuff from at my local supermarket. I thought I'd just share it with you. Okay, so should be able to see there. Notice of conditional acceptance. Notice of conditional acceptance. Notice to agent is notice to principal. Notice to principal is notice to agent. This is to notify you that I am happy to wear a mask as directed, stand 2 meters apart, or participate in a lockdown on the condition that you provide the following. 1. Proof that use of such masks, social distancing, or lockdown can prevent the inhalation. Is that right? Yeah, inhalation of substances or microorganisms at the scale of viruses. 2. Proof that prolonged use of such a mask will not cause hypercapnia, hypercarbia, respiratory adenosis, or anxiety in the wearer. 3. A signed and witnessed statement from you accepting full responsibility and full commercial liability should I be subsequently diagnosed with any of those conditions or suffer an asthma attack or any other respiratory or physical and mental health distress resulting from prolonged mask wearing, social distancing, lockdown, or being 2 meters apart. 4. A complete list of your medical qualifications. Please use the space below to provide the requested proofs of claim and sign and date it in the appropriate boxes to accept full responsibility and full commercial liability. Failure to do so will be deemed to mean that no such proof exists and that you are not medically qualified to make a determination of the effects of prolonged mask use, social distancing in lockdown, or being 2 meters apart from others, and or you are not confident enough to take financial responsibility for my safety as a result of your mask, social distancing, or lockdown enforcement actions. If you do not feel comfortable or sufficiently qualified to sign this liability statement, please pass it on to your immediate line manager to sign. Should I be asked or forced to wear a mask by any member of your staff without receiving the following signed and witnessed liability statement, then John McHewett, Liz Bell, Mark Lemming, Scott Parsons, Riona Bartlett, Mark Crumpton and Max Britton will be served with an affidavit of truth signed under penalty of perjury with full commercial liability, which they will then have 30 days to rebut with their own affidavit of truth signed under the same criteria. MB, if they were to lie on their rebuttal affidavit of truth, that would immediately be an attempt to pervert the course of justice on their part and subject to criminal charges. The 10 maxims of commercial law. 1, a workman is worthy of his hire. 2, all are equal under the law. 3, in commerce, truth is sovereign. 4, truth is expressed in the form of an affidavit. 5, an unrebutted affidavit of truth stands as the truth in commerce. 6, an unrebutted affidavit becomes judgment in commerce. 7, a matter must be expressed to be resolved. 8, he who leaves the field of battle first loses by default. 9, sacrifice is the measure of credibility. 10, a lien or claim can be satisfied only through A, rebuttal by counter affidavit point by point, B, resolution by jury, C, payment or performance of the claim in full. NB, please read the enclosed document, What is a Commercial Lien, extremely carefully. I'll read that out in a sec. If any member of Screwfix staff or management wish to discuss this matter, please do not hesitate to contact me on. Please send any correspondence relating to this matter, including the signed liability statement, to the address below. Okay, so that's a notice of acceptance. This is the liability statement. I, whoever signs it, As the official enforcing the unlawful wearing of masks according to parliamentary preference, I'm fully aware that prolonged use of surgical and non-surgical masks reduce the levels of oxygen that reach the wearer and increases the dangerous levels of carbon dioxide and toxins that are expelled via the breath. I am also aware that prolonged mask use increases the risk of hypercapnia, hypercarbia, asthma and other forms of respiratory distress and anxiety. I am aware equally that low levels of inhaled oxygen have implications for heart disease, COPD and cancer, and any disease facilitated or exacerbated by low blood oxygen levels. I therefore accept full responsibility and full commercial liability should the bearer experience or be subsequently diagnosed with any of the above conditions as a result of prolonged mask use, social distancing or lockdown. And then there's a place for whichever idiot wants to sign that and witness statements. And a bit on the back where they can list the qualifications, because I'm sure the management team is Screwfix, you know, are all doctors and that, aren't they? Right, so where was the... Just one sec, let me get the... what is an affidavit of truth? Here's one I prepared earlier. What is an affidavit of truth? What is a commercial lien? If someone has wronged you by their actions, you have a remedy in law. The common law is the law of the land and is the highest man-made law under which the people of the nation are bound. Under the common law, everybody is equally responsible for their own actions. The office they hold, the authority they may consider they have, and or the uniform they may wear does not protect them in any way, shape or form, simply because they, like everybody else, are responsible for every action they take. This was set in tablets of stone following World War II at the Nuremberg trials. German officers claimed I was only following orders. Yet they were found guilty and hung accordingly. This also forms part of the Geneva Convention to which most countries are signatories, especially the United Kingdom. Thus, I was only obeying orders is not a defence. The reasoning is simple. Before taking any action against anybody else, make sure that what you are doing is lawful and moral. If you suspect that the action you are being ordered to take is either unlawful or immoral, then you must refuse to obey. You can report the order and your reasons for believing it is unlawful and or immoral to the highest authority. You can go as high as you like in the chain of authority, pointing out to anybody who conspires to support the unlawful, immoral order are making themselves accomplices in law, and that, as a consequence, they themselves will be held fully accountable in law. The process itself, okay? In simple terms, you write down the exact truth of what occurred based on your first-hand knowledge, including any necessary supporting documents. You will be writing under penalty of perjury, so do not lie. Make sure any statement you feel, make any statement you feel you cannot prove. You explain the wrong and you claim damages. You claim damages that you feel you deserve. You write this in the form of a sworn affidavit and send it to whoever has wronged you, giving them 30 days to rebut what you have said. You tell them that you will remove any statements that they can prove to be incorrect, but the result, after all removals, will be notarized and placed on the public record. You must take this step because it is honourable and you must remain in honour. You cannot expect a commercial lien to work if you cannot prove this step. Thus, your notice should be sent by recorded delivery such that you can prove it was received, or obtain video recording of the notice being hand delivered. If you do not take this step, you can expect your collar to be felt at some point later, because it is essential and the essence of the common law that a party you consider offended you has the chance to put their side of the story, and you must not deny them that chance. It is very important to remember how the common law works. This is solely by verdicts of juries upon hearing first-hand knowledge-based evidence and unrebutted statements of truth, also based upon first-hand knowledge. What remains unrebutted in substance creates the truth in law. This is the only way the law can work. It relies on people being truthful, with the possibility of perjuring themselves if they lie. Note that in substance does not mean simple denial, as in, no, I didn't. In substance means denial with supporting proof. And remember, I was only obeying orders is not proof, nor is it any kind of defence. Neither, by the way, is I did not know, because ignorance of the law is no excuse. They should have checked and discovered whether or not their actions were lawful and or moral before doing whatever they did. Okay. Being the truth in law, it immediately becomes the judgment in law. This is why, as a witness, you are required to swear to tell the truth, the whole truth, and nothing but the truth, simply because all judgments are based on that. I repeat, it is the only way the law can work. Now that you have an affidavit that remains unrebutted, you can get it notarized by a public notary. Notarizing consists of identifying yourself to the notary with a passport, driving licence or other valid identification and signing your affidavit in his or her presence such that he or she can verify that it was you yourself making your signature. The notary will apply his seal and will sign accordingly. The fees for doing this ranges from £30 to £60. All you need to do from that point onwards is place the fact that your affidavit exists on the public record. This can be done by taking out a small advert in a newspaper. Within the advert, you can invite debt collection agencies to contact you in order to actually exercise the commercial lien debt. What can the lienee do about this? Judges know that they cannot affect a commercial lien because it is based on first-hand knowledge, which they can never have. Only you have that knowledge. Only you can make the statements you made. Thus, there is nothing for them to judge, and they know that. The lien, therefore, has three options: to pay up in full the amount you've demanded, to engage a common law court with a jury of 12 to have their side of the story considered. In this court, you will be able to explain your side of the story to the jury. The jury has the power to wipe away the lien if, for example, they don't believe what you stated, or to modify the amount you have demanded if they think it was unreasonable. This is because the whole process derives from the common law. Note, not statute law, which is subsidiary to common law. Number 3, to wait 99 years with the lien hanging over their head. However, within this period, you can process your lien via debt collection agencies and debt reference agencies. So that's what I'll be doing tomorrow. And we'll see if we can get some managing directors to stop doing as they're ordered and take responsibility for their own actions. Next week, how to get out of speeding fines. Stay tuned for that one.